Roe v. Wade, decided in 1973, was of course the case that established a constitutional right of a woman to obtain an abortion. As we'll see, that right took a certain shape with certain limits under Roe, and has developed and changed in subsequent cases. Under the English common law and in the common law of most states, abortion was not permitted after so-called quickening, that is, after it was possible to feel fetal movement, usually around 15 to 20 weeks after conception. Beginning in the 19th century in Britain and in many states in the United States, abortion began to become subject to criminal statutes. By 1900, abortion was a felony in every state, although in some states there were exceptions if the mother's life was in danger or for pregnancies resulting from rape or incest. Notwithstanding these restrictions, some licensed physicians offered the procedure, and some women also obtained secret procedures or traveled overseas to obtain abortions, often under unsafe conditions. Starting in the late 1960s and into the early 1970s, 17 states had relaxed their abortion laws in response to advocacy by some women's groups, changing attitudes about sex and other factors. Roe v. Wade involved a challenge to the abortion statute in Texas, which made it a crime to procure an abortion except by medical advice for the purpose of saving the life of the mother. In a 7-2 decision, the court held that state restrictions on access to abortion can violate the right to privacy under the 14th Amendment. Writing for the majority, Justice Blackmun stated that the court has recognized that a right of personal privacy, or a guarantee of certain areas or zones of privacy, does exist under the Constitution. The right, he suggested, includes only personal limits that can be deemed fundamental or implicit in the concept of ordered liberty, and has some extension to activities relating to marriage, procreation, contraception, family relationships, and child rearing and education. And this right, Justice Blackmun stated, is broad enough to encompass a woman's decision whether or not to terminate her pregnancy. At the same time, Justice Blackmun noted, this does not mean a woman is entitled to terminate her pregnancy at whatever time, in whatever way, and for whatever reason she alone chooses. The state, he said, may have a legitimate interest in safeguarding health, in maintaining medical standards, and in protecting potential life. And these interests can become sufficiently compelling at some point in pregnancy to justify greater regulation of the abortion decision. The state of Texas had argued that the fetus itself is a person under the Constitution, and therefore has a right to life under the Due Process Clause. In response to this argument, Justice Blackmun stated, the Constitution does not define person in so many words, but that where the term person is used, the use of the word is such that it has application only postnatally. Further, he noted, the common law permitted abortion prior to quickening, suggesting that the framers would not have thought all abortions were invalidated by the 1789 Constitution or the 14th Amendment. The state of Texas further argued that life begins at conception, such that the state has a compelling interest in protecting fetal life from conception. Justice Blackmun replied that, we need not resolve the difficult question of when life begins. When those trained in medicine, philosophy, and theology are unable to arrive at any consensus, the judiciary, at this point in the development of man's knowledge, is not in a position to speculate as to the answer. Nevertheless, Justice Blackmun concluded that the state does have an important and legitimate interest in preserving and protecting the health of the pregnant woman, and it has still another important and legitimate interest in protecting the potentiality of human life. These interests, Justice Blackmun suggested, are separate and distinct, and each interest grows in substantiality as the woman approaches term and, at a point during pregnancy, each becomes compelling. The compelling point for maternal health, Justice Blackmun stated, is after the first trimester, because prior to that point, mortality in abortion is less than mortality in normal childbirth. From and after this point, the state may regulate to the extent that the regulation reasonably relates to the preservation and protection of maternal health. The compelling point for potential life is at viability, he stated, because the fetus then presumably has the capability of meaningful life outside the mother's womb. After viability, the state may go so far as to proscribe abortion, except when it is necessary to preserve the life or health of the mother. In summary, he concluded, until the end of the first trimester, the decision is left to the medical judgment of the pregnant woman's attending physician. After the first trimester, the state may regulate the abortion procedure in ways that are reasonably related to maternal health. After viability, usually the start of the third trimester, the state may regulate or even prescribe abortion except where necessary in appropriate medical judgment for the preservation of the life or health of the mother. Up to the points where the state may regulate, the abortion decision in all its aspects is inherently and primarily a medical decision, and basic responsibility for it must rest with the physician. Notice then, the majority opinion in Roe did not establish an absolute unqualified right to an abortion, and that the final decision was framed not primarily in terms of the woman's agency, but in terms of the medical judgment of the woman's physician. Justices White and Rehnquist dissented. Justice White argued that nothing in the language or history of the Constitution supports the judgment, and that the court's opinion deprives the people and legislatures of the states from considering the issue themselves. Justice Rehnquist filed a separate dissent, reflecting a more narrow interpretation of due process. He did not believe any right to privacy was involved because a transaction resulting in an operation such as this is not private in the ordinary usage of the word. Further, although he agreed that the concept of liberty does embrace more than the rights found in the Bill of Rights, that liberty is not guaranteed absolutely against deprivation, but only against deprivation without due process of law.